One careless syllable can turn a routine traffic stop into a life-altering felony. When an officer walks up and asks, "Any weapons in the car?" the wrong answer can hand prosecutors everything they need before you ever see a courtroom. Today, you'll learn the 5 most common replies that destroy legal defenses in seconds. By the end, you'll know the precise vocabulary that keeps you safe, and the seemingly harmless phrases that can empty your bank account, erase your carry permit, or land you behind bars. Last year, outside Dallas, a 34-year-old compliance manager, licensed since 21, answered with 4 polite words. Those 4 words triggered an 11-month court battle, cost him $8,400 in attorney fees, and ended with a 6-month suspension printed in bold on his record. He thought cooperation was smart. He learned the hard way that roadside silence is golden. Smash subscribe, ring the bell, and share this with every gun owner you care about, because the next traffic stop could be yours. Disclaimer: I'm not an attorney, and this isn't legal counsel. Firearm statutes shift quickly and vary by zip code. Always consult a licensed lawyer and your local ordinances before acting. But we are giving you the rhetorical tools that keep your rights intact when red and blue lights are flashing. Lock in, take notes, and let's walk through the exact sentences that prosecutors highlight in yellow while they chuckle over your police report. Yes, I have a gun. Dangerous phrase number 1. The polite, straightforward, yes, I have a gun. It feels cooperative, even honorable. Here's why prosecutors love it. The instant you utter that sentence, you legally admit possession, but you volunteer zero context, no license, no location, no statutory justification. Under the evidentiary rule of admissions against interest, those 5 words become Exhibit A. You've confirmed ownership and simultaneous presence, yet offered nothing to show lawful authority. In Houston, 2019, a concealed carry holder was pulled over for an expired registration. When the deputy asked, "Any firearms?" he answered, "Yes, I have one." The deputy immediately cited him under Texas Penal Code 411-205 for failing to give proper notification. Texas doesn't want a casual nod. It wants the exact sentence, "Officer, I'm notifying you that I'm a licensed concealed carrier." Because the driver used the wrong wording, he spent 6 Saturdays in mandatory classes, paid $8,200 in legal fees, and watched his license suspended for half a year. His attorney later stated, "If he'd simply used the statutory sentence, we'd have driven away in 15 minutes. So what should you say in duty to inform states? Deliver the magic line, nothing more. Officer, I'm notifying you that I'm a licensed concealed carrier." Then close your mouth. Do not elaborate. Do not point. Do not justify. Most gun owners believe extra chit-chat reduces tension. Response number 2 will show you why that instinct backfires spectacularly. Memorize the phrase now, practice it in the mirror, and make it as automatic as your draw stroke. The side of the road is not the place to freestyle constitutional poetry. It's the place to recite the legally approved script and politely shut up. If the officer needs details, let him ask specific questions your attorney can help you answer later, after the dash cam stops rolling and the adrenaline drains away. It's in my glove box. Dangerous phrase number 2. Volunteering the hiding spot. It's in the glove box, under the passenger seat, or in the center console sounds helpful, even responsible. Prosecutors call that free probable cause. You've just handed them 2 elements they must prove, knowing possession and immediate accessibility. If that storage location violates any obscure municipal rule, maybe the magazine is loaded, maybe the container isn't securely encased, maybe you're within a city park boundary, you've authored their closing argument. In Tampa, 2022, a salesman with a valid Florida permit was stopped for a dim license plate light. When asked about weapons, he cheerfully said, "Sure, it's loaded in the center console." The deputy found the pistol beside a spare magazine, perfectly legal under state law, but the city had a seldom-used ordinance requiring a separate locked compartment inside a vehicle. The driver's own sentence became the evidence proving knowing placement and instant access. Charge: improper exhibition transport. Result: $6,500 in attorney bills, 19 court dates, and a permanent arrest record that pops up every time he applies for a corporate job. His lawyer later admitted, had he simply declined to specify location, the deputy would likely have issued a warning and walked away. Your protective reply after mandatory notification: "Officer, for safety reasons, I'd prefer to discuss exact location with counsel present. Follow every command, hands on wheel, windows down, engine off, but do not narrate the geography of your firearm." Cop Cops are trained to ask follow-ups. Let them fish without your bait. Silence feels awkward, yet silence is a shield that costs nothing and weighs nothing. Practice the sentence aloud until it rolls off the tongue smoother than your favorite expletive, because the moment you point toward your pistol, you point toward months of litigation. I have my permit. Dangerous phrase number 3. The confident "I have my permit" seems bulletproof until the officer radios dispatch and discovers your license expired last month, or was administratively suspended over an unpaid parking ticket you never knew about. In 43 states, giving false information to law enforcement is a separate misdemeanor or felony, punishable by its own fine and jail time. You didn't lie intentionally, you simply verified a status you hadn't checked recently. Prosecutors still label it false official statement, and they stack it on top of the weapons charge. In Roanoke, 2023, a delivery driver flashed his wallet card and said, "I've got my concealed carry permit." A routine check revealed the state had suspended it 4 months earlier when he failed to update his address after moving across county lines. The notice letter sat in a pile of unforwarded mail. He was charged under Virginia Code 182-308 for carrying without a valid permit, plus Code 182-460 for providing false identity information. Total invoice $9,200 in legal fees, 14 Mondays in court, and a criminal conviction that survives every background check for life. The safe language: "Officer, I'm a licensed carrier, and I'd like my attorney to verify current status before we continue." If the permit is clean, your lawyer emails a PDF the next morning. If there's a hiccup, you resolve it administratively without ever having uttered a conclusive statement on tape. Think of it like calling a medical specialist instead of self-diagnosing on WebMD. Let a professional confirm the health of your paperwork before you certify it under oath. Roadside confidence feels good. Courtroom reality feels better when your attorney can say, "My client made no false representation, Your Honor." It's for protection. Dangerous phrase number 4. Explaining your motive. It's for protection, self-defense, or because crime is rising sounds reasonable, even civic-minded. Prosecutors call that evidence of intentional possession. You've just supplied recorded intent to keep the weapon readily accessible for defensive use. If your carry scenario is later deemed illegal wrong county, expired license, posted gun-free zone, your own voice proves you deliberately placed the firearm within reach, upgrading a paperwork violation to an intentional weapons offense carrying harsher sentencing guidelines. In Sacramento, 2023, a permit holder wandered into a privately owned plaza marked "No Firearms" by small font signs at waist level. When questioned, he politely explained, "I carry for protection. My ex-wife's boyfriend threatened me." The district attorney used that clip to argue he knowingly prioritized personal safety over statutory compliance, converting a low-grade misdemeanor into a felony under California Penal Code 26-230. Final tab: $12,400 in attorney costs, 21 months of pretrial supervision, and a lifetime ban on future CCW issuance in that county. When the officer asks why you're armed, the only safe reply is, "I wish to speak with counsel before answering." Do not moralize, rationalize, or justify. Your rationale is between you and your lawyer, not between you and a body camera capturing audio for a jury pool 2 years later. Roadside psychology is simple. The more words you expend, the more ammunition you hand the state. Practice the pause. Take a breath, unclench your jaw, and deliver the magic sentence with the same calm tone you'd use to order coffee. Jurors will never hear you pontificate about crime statistics. They will hear your attorney explain lawful self-defense in a controlled environment where mistakes can't be twisted into intent. I wasn't going to use it. Dangerous phrase number 5. The panic disclaimer. I wasn't going to use it. I forgot it was back there, or I never touched it. Sounds reassuring, yet each variant confesses knowledge while sabotaging every potential defense. Saying you weren't going to use it verifies you knew the gun was present, demolishing any argument it was planted or you were unaware. Claiming you forgot it was there admits negligence. In jurisdictions with storage statutes, negligence itself is a crime. Insisting you never touched it invites forensic comparison, and when latent prints inevitably appear, you've added a false statement count to the docket. In Atlanta, 2023, a rideshare driver was stopped for speeding. An officer spotted a pistol on the rear floorboard and calmly asked, "Is this yours?" The driver blurted, "I'm not going to use that. I forgot it was back there after the rainstorm yesterday." Prosecutors used the admission to prove knowing possession plus failure to secure per Georgia Code 16-11-126. What should have been a 150 equipment citation morphed into a misdemeanor conviction. $1,500 fine, fine, mandatory 16-hour safety class, and 18 months of probation. If law enforcement discovers your firearm, your only sentence should be, "I'm exercising my right to remain silent and I want counsel present." Repeat it like a mantra, even if your pulse is sprinting. Silence is not evasion. It is the constitutional lubricant that keeps the machinery of justice from grinding you into precedent. Nothing you volunteer will improve your situation. Everything you volunteer can be reshaped into a question on cross-examination 2 years later. Memorize the phrase now, practice it in the shower, in the car, at the range condition yourself so the words surface automatically when adrenaline tries to script your apology. Your future self, sitting in a quiet law office paying $350 an hour, will thank you for the 3 seconds of discipline. Your quick legal protection checklist. Let's recap the 5 verbal landmines that vaporize your defense faster than you can say qualified immunity. 1. Yes, I have a gun. Admits possession without legal context. 2. It's in the glove box. Proves knowing control and immediate access. 3. I have my permit. Exposes you to false statement charges if any administrative hiccup exists. 4. It's for protection. Supplies intent evidence that escalates technical violations to intentional weapons offenses. I wasn't going to use it. Confesses knowledge and erases every Fourth Amendment or storage defense. Any single sentence can cost thousands in fees, your carry license, and your freedom. When police ask about firearms, default to the magic couplet, "I'm exercising my right to remain silent and I want an attorney." Say it politely, say it repeatedly, say it until the recorder stops. Think of it as the verbal equivalent of a chamber flag. Simple, standardized, and impossible to misinterpret. Print the checklist, tape it inside your safe, screenshot it into your phone, and review it before every range trip. The best court victory is the one you never need because you kept your story off the street and in your lawyer's inbox. Roadside lawyers bill by the sentence, and the currency is years of your life. When the next officer taps your window and asks the 5-word question, give only the statutory notification required in your state, nothing more than invoke silence. We've armed you with the exact phrases that protect your wallet, your record, and your liberty. Now it's your job to drill them until they're reflex. Make sure you subscribe to Weapons Law Advisor, and don't forget to like and comment on the video to help us reach our amazing milestone of 10,000 subscribers. Every single subscriber matters. Your support is what makes this journey possible.